Got a question asking, the landlord texted a week before Christmas to raise the rent $100. I guess gave this tenant a week's notice, and this tenant wants to know what's the legal amount of time that a rental increase takes effect in California. And I'm going to answer this from the residential tenant's perspective. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, for residential tenancies, for change in terms of tenancy, such as to raise the rent in California, that's governed under Civil Code Section 827, Subdivision B. Okay, they changed the law, I think in 2020, to basically limit how a landlord can increase the rent and what the requisite time frame is to change the rent legally. Okay, so Code Section 8, Civil Code Section 827, Subdivision B gives a landlord two options to raise the rent in writing. Okay, and this applies for month-to-month tenancies, week-to-week tenancies, day-to-day, or other periodic tenancies less than a month. Okay, per its own terms. Okay, so what this landlord has to do is they have to give you a written notice, and it either has to be served personally or it has to be mailed. Okay. And subdivision B basically goes into two time frames, okay, depending on how much the rent is. Okay, so if the rental increase is at 10% or under, a landlord has to give you a minimum of 30 days notice, okay, before that can go into effect. If you mail it, you have to add 5 additional days per this code section. Okay, if you serve it in person, it's effective 30 days after notice is given. Okay, so the classic example is today is like we're in the middle of October, for example, right? And let's say your rental period runs 1st to the 30th of the month. Okay, so to increase the rent 10% or under, you're gonna have to give notice now of that. Wait 30 days. So if your rental period is the 1st of the month, you can't do the rental increase in November. You're going to have to make it effective December 1. Okay. Rental increases that are above 10%. Okay. And this would only apply to people that are not or that are exempt from the Tenants Protection Act, and you're not subject to localized rent control. Okay. Under an ordinance that fixes rents. Okay. You can raise the rent over 10%, but the law states that you have to give 90 days minimum notice. Okay, and then if you mail it, you have to add 5 additional days. So you're talking about 95 days notice to a tenant at minimum. Okay, in writing, served either personally or by mail. So long story short with this tenant's question is no, a legal, like if a landlord text messages you, hey, a rental increase, that's not pursuant to Civil Code Section 827B. Okay, it's just not, that's not the law. Okay, you only got 2 options here of serving a notice. Okay, and in this context, I don't know, if the landlord was raising the rent from like $500 to $600, that's going to be above 10%. Okay, so you might need to give 95 days notice. But if the rent was, like $2,000, it was going up $100, then that's going to be under 10%. So landlords, if you are contemplating raising rents, you need to know what you're doing. Okay, and if you don't know exactly what you're doing, or you need help navigating what a lawful rental increase looks like or how to do it, and you're in the Northern California area, feel free to reach out. Our website's down below. You can book a free case review session to see if we're a good fit and go from there. Okay, folks, put your questions, comments down below. I'll try to answer the questions to the best of my ability. Until next time, folks, I'll talk to you then. Thanks.